A trust protects your house from probate, not from Prop 19. And that misunderstanding is why so many families lose their parents' low property tax base, lose their home, and even when they did everything right. The deeper issue isn't just that some mistakes can't be undone, it's how those mistakes happen in the first place. Not through recklessness, not through carelessness, but through normal human behavior during grief, loss, and family pressure. Families do not lose their parents' low property tax base because they are careless. They do not lose it because they are reckless. Most of the long-term financial damage created by Proposition 19 happens during ordinary life moments. It happens when people are grieving, processing loss, trying to avoid conflict, and attempting to make thoughtful decisions under emotional pressure. The consequences are not created by extreme behavior, they are created by normal human behavior in an abnormal legal environment. This video is a continuation of that conversation because once families accept that some mistakes cannot be reversed, the next question is always the same. How are responsible families still losing their parents' low property tax base even when there are trust attorneys, financial planners, and legal documents involved? The answer is not that families failed to plan. The answer is that Prop 19 fundamentally changed how planning and taxation interact in California. And that change was never clearly explained to the public in a way that connected the systems people already understood. For decades, under the old rules, Prop 58 and Prop 13, families believed that good planning meant proper paperwork. They believed protection came from documents, stability came from structure, and security came from a living trust. In many ways, that belief was justified. Trusts have long been powerful tools for probate avoidance, estate administration, incapacity planning, and keeping your family out of court. But here's the critical disconnect. A trust governs ownership and transfer. Prop 19 governs taxation and usage. These are two separate systems. They operate under different rules, with different enforcement mechanisms and completely different triggers. The distinction is where families become confused. They believe that they are making estate planning decisions, deciding who gets the house, when to sell, or whether to rent it out for income. But the county assessor's office views these same actions strictly on tax decisions. The disconnect is not intuitive and it is not obvious while it is happening. Nothing feels urgent in the moment. There are no warning letters from the county assessors the week after a funeral. There are no formal notices that signal a line has been crossed when you sign a lease agreement with a tenant. There is no alarm bell that rings when a child moves out of state. Life continues in a way that feels normal. Families grieve, homes sit quiet, conversations take time. Decisions get delayed, renting feels practical, waiting feels responsible. Processing feels necessary. Subscribe to this series, California Inheritance Tax Trap, for clear guidance on navigating inheritance, Prop 19, and property tax decisions in California. Meanwhile, the system continues to operate quietly in the background, tracking timelines, usage, transfers, and compliance. The consequences usually appear months later, often in the form of a notice of supplemental assessment or a dramatically higher property tax bill that changes the family's financial reality overnight. By the time that envelope arrives in the mail, the decisions have caused are already permanent. This misunderstanding is compounded by how people view trust. Families believe the trust is the protection. They will think mom and dad put their house in the trust, so we are safe. What most people do not realize is that while trust controls the legal transfer of the home to the children, it does not control the property tax assessment of that home. A home can transfer smoothly through a trust and still be reassessed to full market value. Probate can be completely avoided, and the tax base can still be lost. Ownership can be distributed cleanly to 3 siblings, and the property can still be reevaluated. Legal success and financial outcomes are no longer aligned in the way the families expected. This is not a failure of planning. It is a misunderstanding of what the planning actually protects. Let's look at a concrete example of how this happens. Let me share a story about a family right here in Southern California. They inherited their parents' home. The parents had owned the property for over 30 years. It wasn't a mansion, but because it was in a good neighborhood, the land value had skyrocketed. Their property taxes were around $2,000 a year because of Prop 13. If that home were reassessed in today's value, the taxes would jump to $14,000 a year. The family was responsible. They had a trust. When the parents passed, the trust worked perfectly. No probate, no courts. The children inherited the home. But the children weren't ready to move in immediately. They needed time to grieve. They needed time to sort through 30 years of personal belongings. They didn't want to make a rash decision. So they decided to rent the home out for a year to cover the insurance and utilities while they figured things out. From the family's perspective, this was smart. They were preserving the asset. They were covering costs. They were being responsible. Here is what they didn't know. Under Proposition 19, to keep the parents' tax base, the child must move in to the home as their primary residence and file for the homeowner's exemption within 1 year of their parents' death. By renting the property, even temporarily, they established the property was an income property, not a primary residence. When the year was up and one of the children finally decided to move in, the assessor denied their claim. Why? Because the usage of the property had been established as a rental during the critical window. The tax bill tripled. The sibling who wanted to live there could no longer afford the $1,200 monthly tax payment on top of the mortgage. They were forced to sell the family home. There is another scenario that is devastating families in Orange County, and it involves family with multiple children. This is the sibling buyout trap. Imagine 3 siblings inherited a home worth $1.5 million. Sibling A wants to keep the house and live in it. Sibling B and C want their share of the cash. Sibling A doesn't have $1 million in cash to pay off B and C. So the siblings agree that sibling A will take the title to the house, get a loan, and pay B and C their share. It sounds fair, right? Under Prop 19 in California tax law, this is often a disaster. If the trust distributes the deed to the 3 siblings first, sibling A buys out the others. The assessor views that buyout as a change of ownership. For 2/3 of the property, those 2/3 get reassessed to market value. Sibling A loses the majority of the low tax base. To avoid this, the trust itself usually has to borrow the money before distributing the property. A complex process called a non-pro rata distribution that requires specific players' powers in the trust document and a sufficient cash liquidity. Most families try to do this kitchen table style, transfer the deed, and then figure out the money later. By then, the reassessment is triggered. Even for families who do everything right, the child moves in, files the paperwork, and doesn't rent it out, there is still a math problem that hits hard in Orange County. Prop 19 allows you to keep the parents' tax base, but only up to a limit. That limit is the parent's current taxable value plus $1 million. Let's say your parents bought a coastal home in 1980. Current taxable value, Prop 13 value, $200,000. Current market value, the real value, is $2.5 million. Under the old tax rules, you could often keep that $200,000 tax base under Prop 19. The formula is $200,000 plus $1 million equals $1.2 million. Any value above $1.2 million gets added to your tax bill. Since the house is worth $2.5 million, you are $1.3 million over the limit. That extra $1.3 million gets added to your assessment. Your new tax base isn't $200,000, it's roughly $1.5 million. Your taxes might be $2,500 a year and moves up to $17,000 a year. This is how Proposition 19 causes harm that affect whether families can afford to keep a house or forced to sell. They affect whether a legacy property becomes a sanctuary for the next generation or a financial liability that drains their savings. This perhaps is the most painful. These taxes surprise destroy family relationships. When a surprise $15,000 tax bill arrives, siblings start pointing the finger. Why didn't you move in sooner? Why did we rent it out? Why didn't the attorney tell us? Financial pressure changes relationships. Decisions become urgent instead of thoughtful. Conflict becomes likely. The property stops being a symbol of mom and dad's hard work and starts feeling like a burden that is tearing the family apart. This is why education matters more than documents in the Proposition 19 era. If you are navigating this right now, here is what you need to understand about the timeline. 1, the clock starts at death. The 1-year clock moved in and filed for the homeowner's exemption starts on the date of death, not the date you get the keys or the date probate closes. 2, occupancy is everything. Intent doesn't matter to the assessor. Occupancy does. You must treat the home as your primary residence. This means changing your driver's license, your voter registration, and your mailing address. 3, be aware of renting. If you are the personal representative, there are extreme cautions. If the beneficiary intends to keep it, the short-term rental could cost the family thousands of dollars a year in perpetuity. 4, check the numbers, being the market value and the gap between the $1 million. Inheriting properties can afford a new reality. In the Prop 19 environment, inaction can carry the same consequences as action. Silence allows timelines to expire. Delay allows exemptions to lapse. Good intentions can still lead to irreversible outcome. If you are watching this and feeling overwhelmed, that response is understandable. The rules change, but the public education never followed. Families are navigating a system they were never trained to understand, using tools built for a legal era that no longer exists. But clarity threatens stability. Understanding creates control. The goal of this channel is not to rush you into action, but to help you see the invisible lines before you cruise right past them. If this video helped, you understand what is happening the surface of the California. These decisions clearly and calmly, so families move forward with confidence instead of regret. If you're dealing with an inherited home in California and you're not sure what applies to your, pause. Don't sign anything yet. This is exactly what I help families go through.